Welcome to the Law, Your Money and You. I'm Roberta Saphire, an attorney in Sharon.
And I'm Camille Barron, a financial advisor specializing in asset protection, also here in Sharon. In this show, we bring you important information about legal and financial issues that you, our viewers, have asked for. Our expert guests give us their opinions on a variety of concerns and questions that people have asked. So today, Roberta, who was our guest?
Our guest is Andy Nebenzahl. He's an attorney right here in Sharon. He's a very well-known attorney, and he's right here now, but a little background on him. He was the chairman of the Charter Commission. He's very well versed in litigation, estate law, but today he's going to tell us about a recent snow and ice fall case.
Exactly. Where shall I start? There's a recent change in the law based on an opinion of the Supreme Judicial Court that came out this past August. And historically, in Massachusetts, it was very hard to prove liability for a slip and fall on ice. You had to overcome a threshold that the ice did not occur or the snow did not occur as a natural accumulation. In other words, you had to show that somebody had altered a natural condition and made it dangerous as a result of that alteration before one could institute a negligence suit.
So that if a homeowner, a landowner, or a business owner, and I want you to get in the differences, if they shoveled, then they had a problem that they might have been negligent, they disturbed it. So a lot of times they just did nothing, which could be just as bad.
Well, that's right. And in fact, that's what this case dealt with. A fellow named Papadopoulos was going to a Target, and on his way into the store, he slipped on ice. And the lower court originally said that he was not able to sue for his injuries because there was no evidence that the ice that had formed wasn't a natural accumulation. There was no evidence that something had been done in the parking lot, plowing and so forth. So he was not permitted to sue. His lawyers took an appeal to the Supreme Judicial Court and asked the court to eliminate the distinction for the ability to sue for injuries between a natural and an unnatural accumulation of snow and ice. Their argument was negligence is negligence. If they fail to provide a safe place, as the law requires them to do, whether in the case of snow and ice that is a result of a natural condition or an unnatural condition, shouldn't be required to be distinguished. And the court actually took that position for the first time and changed the law in Massachusetts. Now, any defective condition, regardless of its origin in the snow and ice context, is actionable if it's a dangerous condition. So landowners now have the affirmative obligation to take the proper measures to keep their property safe, whether the condition originated from a natural snowfall or an ice storm or something else.
How long was that previous interpretation of natural accumulation in place?
The last time, it's been in place for years, I'd say over 100 years. The last time the Supreme Judicial Court spoke about it was in 1994 in a case called Sullivan versus the town of Brookline, in which they reaffirmed that principle. And I know one doesn't like to read, but let me just very briefly do that. In that case, in 1994, the law was stated as follows: the duty owed by a property owner to someone lawfully on the owner's premises is one of reasonable care. In our most recent decision addressing the owner's duty with regard to snow and ice, we made clear that this duty is not violated by a failure to remove a natural accumulation of snow or ice. And that's what you were saying. If somebody is away for the weekend and decides just not to shovel their walk, and somebody comes on lawfully to their walkway and gets hurt, they couldn't be sued because it was simply the result of a natural accumulation.
And what was the rationale for this?
Um,
I mean, the rationale
The
for
old
having
rationale.
having it that way
We
for
live
all
in
those
New
years.
England. Snowfalls and ice storms are an inevitable part of daily life in a New England winter. And for years, the court held you don't want to hold landowners to a standard of having to chase every snowstorm. And now, as sometimes tort law evolves, the way modern life evolves, and we have, particularly in a commercial setting, as the Target case was, a better ability, a greater ability to deal with snow and ice storms, and we have an enhanced, or not an enhanced, but a consistent duty to use reasonable care to provide for the safety of others to whom you have a duty, then that becomes the standard. Did the landowner use reasonable care? Not was the condition natural or unnatural. There was a ton of litigation that was caused by deciding those questions in any particular case. The SJC finally said, we don't really need to have that inquiry. The simple inquiry is, can somebody who was injured prove that that injury was caused by the landowner's failure to use reasonable care?
Now that was Target, which is a commercial corporation. The other one was the town of Brookline,
Well, yes.
which is a municipal corporation. What about, like say Camille goes away for the weekend, and what's the difference if her tenant falls, or somebody comes on her property, or maybe somebody's knocking on the door soliciting, she didn't invite them? So where's your differences?
Okay. Really good question. Requires, I hate to say this, a bit of a long-winded answer, but I'll try to capsulize it. The duty owed by a landlord to a tenant is in a class by itself. If a landlord of a piece of property that has tenants in it, multiple family house, office building, or whatever, and the tenants come and go, then the landlord has a duty to make sure that the premises are safe.
So this
Natural
snow and
accumulation
ice didn't matter.
didn't generally apply in a landlord-tenant context because there was a statutory and contractual obligation for the landlord to provide a safe means of egress and walking out to people that come and go. So that is in a league by itself. The homeowner who has some solicitor come to the door, one could argue, is that solicitor an invitee? Was he invited to do that, or was he trespassing? A trespasser gets treated a little bit more harshly under the law. He didn't have permission to be on the premises, so he doesn't necessarily get to tag the landowner with the same duty as to somebody who is lawfully on the premises. And if you listen carefully, when I read that sentence from the Sullivan v. Brookline case, it started out with the duty owed by a property owner to someone lawfully on the owner's premises. So the law has historically made a distinction between a trespasser and somebody who's lawfully there.
That's like you're not lawfully there and the dog bites you.
Right.
I got my old dog bite case.
What about employers and employees?
Well, that, again, the duties owed to an employer and employee always, the employer always has an obligation, an affirmative obligation to provide workplace safety. And the different question is, and it'll be interesting to see how this evolves, what about the postman, the letter carrier? People are away for a week in February, and he or she comes to deliver the mail and is injured as a result. The family was away. They didn't necessarily know that it was going to snow. They didn't have anybody take care of the walk, and somebody gets injured as a result. If there is an area of liability that I think will be revisited, it might be in that context, because a lot of homeowners are going to say, you know,
He should have
what is
known.
reasonable care? No, what is reasonable care? Should I have anticipated that it would have snowed? Should I have made sure that I hired somebody, maybe a teenager down the street, to take care of my walkway when I was not here?
But how
What about
about-
snowbirds who go
Yeah.
to Florida for the winter and just not bother for a month or so, and it snows, and somebody is lawfully on their premises, the UPS delivery person or somebody of that nature?
Well,
I-
doesn't the UPS person and the postman who's there every day, the postman probably knows they went away or they come away. Shouldn't he be a little more careful?
Well,
Isn't
that's always a
there,
question. You always, in any negligence case, a jury, or the judge if it's a jury-waived case, will always weigh whatever negligence the plaintiff alleges was committed by the defendant against any negligence that was committed by the plaintiff, and that's called comparative negligence. So when a jury is asked, was the defendant negligent? This could be true in an auto accident case, in a slip and fall, whether it's ice or not, and in particular in slip and fall cases, frequently one of the defenses is that the person who was injured wasn't looking where he was going, and or was running, or wasn't taking proper measures to protect his own safety. And then it becomes a question of who was more negligent. And a jury is asked precisely what percentage of the negligence was the defendant, if any, and what percentage of the negligence was the plaintiff, if any, and it must add up to 100%. So the law in Massachusetts is, if the plaintiff is more than 50% negligent, he cannot recover anything. It's not true in other states. Some other states say that a plaintiff can recover that percentage that the defendant was negligent. So even if the defendant was 75% negligent and the defendant was 25% negligent, in those states, the plaintiff can still recover 25% of his damages. Not the case in Massachusetts. In Massachusetts, if it's 50-50, the plaintiff gets to recover 50% of whatever the jury assesses as damages. If it's 51 for the plaintiff, 49 for the defendant, he gets nothing, or she gets nothing. So that's the state of the law of across the board in negligence cases in
So
Massachusetts.
what about other states with regard to this natural accumulation?
Well, it certainly isn't an issue in Florida, I can tell you that.
I was going to say that, or parts of Arizona.
And I really am not familiar with other states' law on that.
I thought our law had been unique. Of course, Massachusetts is always unique. You know what I wanted to bring out? This particular case, I looked up, there was, I wanted our viewers to know, there was no jury involved. Because a lot of times people hear, well, they make the decision and then they find the reason why.
Right. Well, that's actually...
But there was no jury. Did this find in his favor or just allow him to bring an action?
The procedural course of this case is now at a point where he can have a jury trial. What had happened is the defendant in this case filed, after all the discovery part was done, depositions were taken, the defendant filed a motion for dismissal of the case on the theory that there will not be any evidence introduced that there was an unnatural accumulation of the ice, that the testimony was going to be consistent that the reason for the defective condition or the dangerous condition was the result of a natural accumulation of ice. And the lower court judge said if that's the case, the law compels dismissal of the case. An appeal was taken to the Supreme Judicial Court, where it was argued that the distinction between natural accumulation and unnatural accumulation should be eliminated. And that's in fact what the court did.
It's a landmark case. Now,
It's a landmark
has there been
case.
a rush? You think there's going to be a rush now on slip and falls?
Well, first of all, again, this occurred in August, so unless there are lawyers that are going to take a second look at slip and fall cases that they've rejected from last winter or the winter before, then you know we're in a different legal landscape. I don't think there's going to be this rush to the courthouse, and here's why. Traditionally, for a lot of reasons, slip and falls are among the hardest cases to win, just for the reason that I identified before. Inevitably, there's going to be great concentration on what was the plaintiff doing? Why did the plaintiff slip? And so really, you're going to permit plaintiffs who have serious injuries to bring a lawsuit for slipping on snow and ice. But quite frankly, it doesn't happen that often. And all we've done here is eliminate the level of proof that was formally the burden of the plaintiff to show that this occurred unnaturally. So there certainly will be additional cases brought, but I don't think that it will be statistically significant so that all of a sudden we're going to have a flood of litigation in the Massachusetts courts.
So now if we think about the insurance implications of that,
Sure.
Liability insurance, starting with business and then homeowners, does this change anything in terms of what they should or shouldn't be doing to protect themselves against cases like this?
Well, the short answer is the only thing they should be doing is having liability insurance. That's exactly what liability insurance is for. Now, the question may be, are insurers going to now have to use different underwriting criteria when they price policies? And my guess is that insurers will take that opportunity to say, oh, of course, we have to charge more for insurance premiums, even though, you know, somebody like me who's lived in the same house for 23 years and has never had a claim and not likely to have one, you know, I don't know if it really will increase claims that require coverage or to the extent that they're going to claim that they need to in their rates. We'll see.
So in a sense, by restating what a property owner is responsible for, doesn't that bring slip and ice cases into the realm of all other negligence cases?
Yeah, that's a good way of stating it. There is not an exception in the snow and ice context anymore for injuries that occurred that came from natural accumulation of snow and ice.
Okay.
What about like condo associations?
Well, condo associations, again, are going to have to perhaps take better care to make sure that their common areas that are open to the public, and they've always had the obligation, again, they've always had the contractual obligation within their condo documents and the duty to their condo owners and people that are there to take care of the walkways. And I don't think that that's going to necessarily change or should change their practice very much. If it snows, they got to shovel it. You know, if it's icy, they got to salt it. I mean, again, the inquiry is reasonable care. Was what they did or did not do reasonable? And if it was, regardless of the injury, then they weren't negligent. So, you know, I don't see that there's going to be a huge difference in the obligations of property owners.
Now let's complicate things a little bit.
Okay.
Suppose I'm a property owner and I own properties all over Massachusetts, and I have a contract with a snow plowing company that they are going to plow if the snow falls at a certain amount and within a certain amount of time.
Sure.
And so the contractor who was supposed to do it didn't exactly abide by that. So somebody comes into the property, it's a tenant, or
Right.
it could be a visitor invited, and they slip and fall. We know that the property owner has the primary liability.
Correct.
But is it fair to say that in turn that property owner could then say that the contractor was at fault because of the contractual obligation that they had to the property owner?
The short answer to that question is that it is not likely that the contractor would owe a duty to an invitee, somebody who's been invited by somebody who lives there. However, the contractor's not off the hook, because if I were advising a property owner, which I do in my practice, I would make sure that if that property owner hired a contractor, that obviously, first of all, that contractor was reputable, but secondly, and almost as important, insured, and make sure that within your contract that the contractor had insurance for any errors that he may have made. Now, again, if we have a blizzard and he's supposed to come within a certain amount, or she's supposed to come within a certain amount of time and is late, you have to look at what happened in the context of what was reasonable for him.
Yes.
So it's not going to be strict liability in that somebody fell, got hurt, and therefore can collect. You have to look at what was reasonable.
So that's the key, reasonable.
The key is make sure your contractor is insured. And there is, snow plowers should have insurance. They drive big, heavy trucks. They're out on the road. They're in dangerous conditions. It's not just whether or not that person negligently plows the snow on your driveway that's open to the public, but that person should have insurance because he's driving out in a dangerous condition with heavy equipment.
We're going to wind up this portion of it because we're going to go into the You've Got to Be Kidding, but do you have any interesting cases going now?
I have a lot of interesting cases. A lot of
you'd like to
interesting
let
cases.
the viewers know?
Off the top of my head, no. I handle a number of cases, both involving defective products, handling a case on behalf of a poor guy who was driving down a highway in New Jersey, and the tread on his tire separated, and his pickup truck rolled out of control, and he was ejected from it. Very, very sad case. I have a number of more run-of-the-mill cases, and it's just it's a good practice. I enjoy it.
It's good.
Glad I'm in Sharon, and
well, one of the words you use is statutory law. Why don't we end on that? Tell the people the difference between statutory law and common law.
Well, common law is law that evolves over time, started in the British system, where judges interpret conduct as being offensive to an ordered society. I mean, that's a fancy way of saying it. But it is law that's made by case law that comes from courts. Statutory law are the statutes that are passed by a legislature. And, the old adage that a legislature makes the laws and the courts interpret it is true, but only to a limited degree. There is certainly a great deal of law, and this is not legislating from the bench, but it's just the natural order of the way the law has developed in both England and the United States for 400 years, that comes out of decisions by judges, and that's common law.
Oh, that's
Is that also
good.
known as case law?
Yes.
Okay. So what I was reading about this, getting back to the slips and falls, is it still has to play out in case law as to how this will actually manifest itself.
Well, this was the result of case law. This was a case that the Supreme Judicial Court decided. Now, if the legislature didn't like that decision, they could pass a statute that says, no, we think that to prove liability in a snow and ice case in Massachusetts, the law is going to require an unnatural accumulation to be proven. The legislature has that prerogative. It can pass a statute restricting this case law, and the legislature would be supreme.
Maybe they could pass a law, no snow or ice.
A lot of
Do they have
people
that
would
much
love
power?
that. They think they do. Some.
Okay, so
not ours.
that's our wonderful visitor, Andy Nebenzahl, right in Sharon here, and now we're going to our segment called You've Got to Be Kidding. And Andy, there's a little portion where I'm going to ask you what you think, but you make sure you say You've Got to Be Kidding first. This is a matter where a person was in the hospital. They thought he had cancer. Recently happened. down in one of the hospitals down the Cape, and they operated on him to get this tumor out. And she's laughing already because I told her beforehand. You're supposed to say, "You've got to be kidding first."
Oh, wait.
Anyway, it turned out there was
I'm waiting
a pea.
to hear what happened.
There was a pea growing inside of him, a pea pod, and it was growing inside of him.
You've got to be kidding!
You took the words right out of my mouth.
Yeah. No. Now, what would his liability be? Say meanwhile he's getting sicker and sicker and sicker. This is years before they finally operate. He's going through all this.
I personally
treatment and
think that he
everything.
would have a very good case against his esophagus.
Against
His
his
esophagus, his
doctor.
esophagus
You've
did
got
not
to be kidding.
properly digest that pea pod that allowed it to be stuck there for so long that it started to grow. And that esophagus failed his duty to this particular patient.
Yeah, how much money do you think his case is worth?
Not much.
You don't want to handle it.
I probably would reject that one, yes.
There's a, what have you ever, I found one where there, well, I didn't find, someone emailed us where the person, another attorney emailed us, where a person sued a dog, instead of, not the owner, but the dog itself. And now, you must have heard of, you do estates and trusts. Have you
Yes.
had any where the people have left money to their pooches?
I did not handle Leona Helmsley's estate. And she's the only person that I know of that set up a trust to take care of her pets. So, no, I would also probably reject that case because I don't think the dogs have
kidding.
insurance. I think that homeowners have insurance.
Well, who should they have sued?
Perhaps the dog owner, because
The dog owner?
or keeper of dogs in Massachusetts have strict liability for dog bites. So
And what does that mean?
that means that you don't have to prove negligence. If you're bitten by a dog in Massachusetts, the owner or keeper of the dog is strictly liable for the damages that result from the dog bite.
Now, I got a whole bunch of stuff here that Camille gave me. She's in finances and everything on what's tax deductible, you know, and financing this and the strange things that are tax deductible. But instead of doing this, that case, the snow and ice case, are personal injury settlements tax deductible?
Well, it's not that they're tax deductible, but they're not taxable.
They're not
Oh,
taxable.
not taxable.
No.
That's what I meant.
No. The settlements of lawsuits for disability or injury are not taxable. There are some lawsuits, such as if somebody sues because they've been fired from their job inappropriately, and the specific allegation is that they lost their wages going forward, then in some cases those settlements or those awards are taxable as income. But physical injury, emotional injury damage awards are not taxable.
Because what's interesting is you have somebody who collects some type of disability or something like that, or they collect based upon their income, and then they get this huge settlement. So that's not counted? You don't think?
It is not counted, no. Not if it's not if it's a tort case, not if it's a personal
Is there
injury
any ice
case.
outside?
Not yet.
The lawyer's fees, of course, are taxable to the lawyer, but not to the...
Always.
Yes, right.
Always.
Yes.
Well, I think that that wraps it up.
Yes, I think it does, and I think we could go on and on, but we are out of time. We'd love to have you come back. We have
happy
lots
to.
of
This was fun.
our viewers send us lots of emails after each one of these, and I'm
Okay.
sure we'll be getting some
Yeah.
for this one.
Oh, absolutely. Thank you, Andy,
My
very
pleasure,
much.
Roberta.
Thank you,
Camille.
Andy.
And remember, you're wrapping it up?
Remember to send us your emails, because we need to know what you want to hear about. We need to know what's most important to you. If you have any funny stories and you want us to talk about them on You've Got to Be Kidding, we'd love to have that. Remember, this is your show. The law, your money, and you!